Call, please.
Chair Renahan.
Here.
Member Chaplin.
Here.
Member Covert. Member Desart. Here. Member Eckhoff. Member Garcia.
Here.
Member Krajewski. Member Ozog. Here. Member Pachowski. Member Schwarzy. Member Salmon. Member Zay.
Okay, thank you. We do have a quorum. Do we have any public comments?
Yes, we do.
Go ahead.
Okay, the first comment is from Amy Lippert. The subject is common sense gun control. Now, the comment reads, I am an Elmhurst wife and mother, an American historian, a lifelong educator, and the treasurer of our daughter's public elementary school PTA. I'm not naive enough to assume that our community is somehow magically shielded from the epidemic of gun violence in this country, or that my daughter is as safe as she ought to be wherever she is at school, or any public gathering for that matter. I'm calling on you to restore our rights and freedoms, to be secure in our own ability to venture anywhere without having to worry about getting shot. I want an assault weapons ban, universal background checks, and a mandatory waiting period to buy a gun, strengthen red flag laws, a ban on extended ammunition magazines, a ban on bump stocks that, in effect, make semi-automatic rifles automatic, and I want the minimum age to buy a semi-automatic rifle raised to 21. I want each of you to do everything in your power to help end this epidemic of gun violence that is destroying our country. As your constituent, I demand it. That ends this comment. The next comment is from Stasia Farrar. The subject is assault weapon ban for DuPage County. The comment reads, let's follow the lead of Cook County and ban the sale and possession of assault weapons and semi-automatic rifles, including AR-15s. From 1994 to 2004, when it was illegal to transfer or possess large capacity magazines and certain semi-automatic firearms in the U.S., mass shooting fatalities were 70% less likely to occur. When the law expired in 2004, there was a 183% increase in high fatality mass shootings and a 239% increase in deaths resulting from such shootings. Banning assault weapons and semi-automatic rifles in DuPage County is just one step, but one that could prevent the next tragedy from happening in our community. That ends this comment. That ends all comments.
Okay, can you make sure that the committee receives those, Sally?
Yes.
Thank you very much. All right, so good morning, everyone. So thank you for your attention today as we continue to work through the Safety Act components. I know for one, I appreciated hearing from our Chief Judge about the Safety Act requirements in case of an incarcerated person to come before a judge for careful consideration before continued detention. So I thought it'd be helpful to continue this impact conversation and to have analysis of the Safety Act from an academic point of view. So it's my honor to introduce Professor Alexa Van Brunt, Clinical Professor of Law, Northwestern Law School. She directs the MacArthur Justice Center, where as an attorney, she litigates complex civil cases with a focus on criminal legal system reform. Her areas of expertise include civil rights, criminal law, and constitutional law. Professor Van Brunt is a recipient of Award for Excellence in Pro Bono Service from the U.S. District Court for the Northern District of Illinois and the Illinois Voters of Illinois Independent Precinct Organization Legal Eagle Award. Prior to joining the Justice Center, she clerked for the Honorable Myron Thompson, U.S. District Court, Middle District of Alabama. And Professor Van Brunt received a law degree with distinction from Stanford Law School and a bachelor's degree magna cum laude from Brown. So welcome, Professor. I'm just going to ask before we start here that the committee hold any questions until the end. And I'm going to call on speakers, members for questions to help the speaker navigate the room. It's a little crazy here with the Zoom. So, all right, turning it over to you, Professor Van Brunt.
Thank you so much for having me. It's really an honor and a privilege, and I will just offer a couple brief remarks and then happy to answer any questions. I realize there's a large agenda for the committee to consider. As my introduction makes clear, I do teach civil rights litigation at Northwestern Law School. I am deeply invested in the Safety Act and the changes that are going to come forward with that act in January 2023, because it impacts so much of our work on the ground. And with that, I thought it was appropriate to start with a bit of a reframing of the issue. There has been a lot of content on media, social media, and newspapers throughout the state of Illinois about what the Safety Act is, and much of it is just false. So let's focus on what it is. The Safety Act, and specifically the abolition of cash bail, which is what I think we might focus on today, goes into effect in January 2023. This is an absolutely wonderful thing for Illinois, because currently the state locks up people not based on community safety concerns, not based on concerns about individual safety risk, but based on how much money they have. If they have money, they pay the cash bond assigned after their arrest and they go home. If they do not, they stay in jail for a term of their incarceration, which can last up to years before they actually go to trial. Meaning we have a system of pretrial detention in this state that is not linked to safety or community, but instead is linked to economic status. It's straight out economic discrimination, and it impacts people who are Black, Latinx, and poor most significantly. So what does the abolition of cash bond do other than change the way we lock people up? What it does is it actually makes our communities safer. People who are incarcerated while awaiting trial, remember, everything we're talking about here is relating to people who have not been convicted of anything, suffer devastating ripple effects on housing, jobs, education, mental health, and more. These disruptions destabilize our communities and they make us all less safe. People who are incarcerated for as little as 72 hours or 3 days are 2.5 times more likely to be unemployed 1 year later. That makes sense. Even 24 hours in jail often means the loss of a job, the loss of childcare, the loss of the ability to support your family. It has massive impacts, and that's only after a day. Past incarceration of any kind, including pretrial detention, reduces annual income by as much as 40%. The impacts of pretrial incarceration can make people more likely to be arrested in the years following their time in jail, regardless of whether they were found guilty or not. So given this, given the fact that pretrial detention destabilizes communities and families, and in fact, does not keep communities more safe, it makes so much sense, both from a community safety perspective and from a common sense perspective, to have a system that is actually based on risk, to have a system where judges evaluate evidence put forward by the prosecution and determine who is a flight risk, who is a safety risk, and who should be allowed to be released so that they can continue to support families, go to work, go to school, and fight their case on the outside. That is what the Pretrial Fairness Act, part of the Safety Act, does. And as I said, I think it's a monumental step forward for the state and something we should be massively proud of. Now, obviously, this is a very long statute. It has a lot of ins and outs to it, and I'm happy to answer specific questions about either the cash bond aspect of it or other provisions governing arrest or any other aspects of it. But I do want to reiterate that the community safety messaging that has surrounded this bill has often been wrong and has been misguided, and in my view, has been a significant effort to foment fear-mongering in an election season. And that's unfair to the people of Illinois, and it's unfair to the communities who are most impacted by the cash bail system that is now in place. And I'm happy to take any questions.
All right, great. Thank you. Member Desart had requested to go first.
Thank you so much. Professor Van
Yeah.
Graan,
Thank you so much for being with us here today. I really appreciate that.
Of course.
Couple of questions. I basically want to play truth or false
Mm,
based on some of the things that I've read. I'm going to be talking about our own DuPage County elected officials. Our state's attorney, Bob Berlin, said police shall issue a citation for Class B and C misdemeanors, which includes trespassing. That means police can no longer arrest somebody for trespassing unless they present an obvious danger. True or false?
well, I think I can't say either true or false. It's true that for pure trespassing, police are supposed to issue a citation. Let me say this. People are not being arrested for trespassing now. Trespassing is a very minor offense. It's very different if someone is on your property and refuses to leave. And that gives rise to a threat, at which point it is an arrestable offense. And, you know, I think the DuPage County Sheriff has admitted as much. Most law enforcement have admitted as much. If someone refuses to leave your property, then it likely rises to the level of a safety threat and you're talking about an arrestable offense. But trespass literally means you step on somebody's yard. I live in the city of Chicago. We do that all the time. It's a small area of grass and yards. So I really think we have to talk about, we have to refocus on what we're talking about here, and people aren't being arrested for trespassing now. And that is just really a red herring to, again, foment fear, I think, about this bill.
Thank you. The jail gates are going to magically open to everybody, rapists, murderers, domestic abusers, magically on January 1st.
Yes, the old purge theme that is false. Okay, so people now, Bob Berlin now has the capacity and the responsibility to file a petition to seek to hold people who he thinks constitute a public safety risk. That is the law now. Anybody who is in on a cash bond will not be automatically released in January. In fact, what will happen is there will be an orderly process by which prosecutors like Bob Berlin will submit petitions to hold people just as he can now. Judges will consider the evidence of safety risk and make a determination about whether somebody should be held. Of course, somebody who has committed or is alleged to have committed rape or high degrees of sexual assault or gun crimes or any forcible felony, and certainly murder, is going to have a high hurdle to pass to be released. That is the law now. Will be the law in January, but certainly the gates are not going to be open. There's going to be an orderly process based on evidence of risk and evidence of flight risk. Anyone who is a risk of flight can be held, or willful flight can be held pre-trial after January 1st. So, again, more fear mongering, not the case, and really not a huge change from what exists now, wherein the prosecutor has the ability and the right and the burden to prove someone is a public safety risk in order to have them detained pre-trial.
I have a million other questions, but I know my colleagues do too, so I'll just ask one more. A Chicago television political reporter said to me, in criminal court, the judge has like 2 sheets on somebody and makes a decision. Boom, you're up. I scanned 2 sheets and boom, you're next. So how do judges really discern who's a flight risk, who's a danger to the community in just like 30 seconds?
Well, that's on the state. It's the state's burden to prove by clear and convincing evidence under the statute now and under the statute in 2023 that someone's a flight risk or a threat. And they do that by presenting evidence of the crime alleged, evidence of some criminal history, the normal stuff. So a judge was going to consider the evidence presented by the prosecutor. This is the orderly system of justice that we have. We don't have a system of arbitrary detention, which is essentially what cash bail is now, whereby a judge looks at a person and says, I don't really like the look of you, $250,000 cash bail. That's not based on anything. That's not based on evidence. That is not how we do things in America. So what's going to go into effect is essentially a much more reliable, a much more evidence-based, and a much more, hopefully, equitable system of pretrial release.
Thank you, Professor. Thank you, Chair. Thank you. We're going to go Vice Chair Pachowski and then Member Chaplin.
Thank you. Isn't the burden of proof higher? It's a willful risk of flight and clear and present danger. It just seems to me that we've gotten a much tighter standard that we have to go through now. And I just find it unique that we have so many state's attorneys and our sheriff and our state's attorney adamantly opposed to this. I don't see how it can make our community safer. And I think our sheriff and state's attorney respectfully disagree with you with that. But all of this stuff costs money. And I like they pass legislation, but they don't tell us how we fund it. We got to fund it ourselves. So we have to have more state's attorneys. We need more public defenders. And we have to pay for this. If this bill was so good, they should have properly funded it, and they haven't. I don't think this makes our community safer. And I think we should look at more of victims' rights than criminal rights.
Okay, well, I'll take a couple of those. First of all, many state's attorneys are in favor of this. Eric Reinhart just had a very powerful op-ed yesterday in the Chicago Tribune. I was going to share it in the chat, but I don't think I have a chat access about how he supports the Safety Act and how it'll be good for Lake County. Bob Berlin has actually gone on the record saying he is not opposed to the elimination of cash bail. The standards are not different. Right now, a state has to prove by clear and convincing evidence that someone is a risk to the community or a flight risk. That is what they will also have to do in January. That standard has not changed. It's just that right now, prosecutors aren't doing their job and they're not providing evidence to prove that standard, and judges are not submitting findings based on that standard. This law makes clear that they have to do that if they want to hold somebody. Again, that is our system of justice in the country, where you are presumed innocent before being found guilty, and where we do not lock up people based on how much money they have. As for the resources of public defense, I agree with you. We have an indigent defense system problem in our state. Public defenders are underpaid and they are under-resourced, but that is a problem that has existed for years. And that is something legislators should address. But right now, I mean, we shouldn't be holding people in jail because we want resources off their backs, which is what is being done with cash bail, where it's being used to fund systems and fund public defense systems. I mean, that's basically immoral, but also should be unlawful. So what we need to do is focus on what systems do need more funding, like indigent defense, to support the right to counsel in this state. And prosecutors, if they want to hold people in prison or in jail, they need to meet their burden to do so. And that's just the basic adversarial system that we have in this country. And that hasn't changed for what's in effect now. It's just going to be more tightly enforced.
You use the word risk of flight. Isn't it in its standards a willful risk of flight? Is willful risk of flight different than what you should have said willful, or does it make a difference if it's not?
Willful, you're right, it is willful. And that's just to differentiate from somebody who, for instance, forgot they had a court date. And that, I mean, do we want to lock up somebody who just forgot they had a court date? Willful risk of flight means they are trying to evade the court. They are trying to evade process. They are in hiding. They do not want to come to court. There should be some showing that that's the case. If someone comes and says, oh my God, I thought it was on the 27th, instead it was on the 26th, do we want to lock them up pretrial for that? There should be some showing that the person knew about the court case and willfully decided not to go. And I think that's just basic fairness and common sense. And that's all that means.
And one other standard is obvious threat to the community, correct?
Correct.
All right. How is that defined?
Well, it means there has to be a threat to an identifiable person or persons. Right now, what happens is judges get up and they say, well, I'm going to say that you're a threat to the state of Illinois. No evidence that that person actually is a safety threat. No findings that that person is should be held by clear and convincing evidence as the statute now requires. So instead, they make some very generic statement like that, and that doesn't meet their burden. Right now, it makes clear that you have to say, okay, if somebody is charged with a domestic violence offense, they're a threat to this person. And frankly, most people charged with those offenses are probably likely to be held because of that. It's an articulable, specific threat. Same with certain gun crimes. If we think somebody who committed a gun crime is a threat to a specific person or groups of people, the judge says as much, finds as much, the state offers evidence as much, and then they can be held. It just makes clear what the burden is. And you can't go around saying, oh, I find you're a a threat to the state of Illinois, which frankly is what's been happening. And that's just not what the law.
I have a carload of fentanyl. Would I be someone who should get a bond then? Because I'm not a threat to anybody, but I'm talking about drug offenses, with serious drug offenses. They would be able to get a cashless bond, right?
Okay, so any forcible felony over a class 3 or showing a risk of flight for willful flight for any offense is subject to detention. If the state shows, again, it's on the state. We put a lot of, there's all these like comments about how the floodgates are going to open. The state just has to make a slight burden of burden of proof to hold somebody. So fentanyl. Okay. So if the person had a gun on them, they are subject to detention. If they used any threat of violence, they are subject to detention. It's up to the state to prove the community risk there, or the risk of willful flight for fentanyl. So it's very fact specific, and it's up to the state to meet its burden on that.
All right, thank you. I think I'm going to limit one question per person. So because we do have executive session today, I have Chaplain Krajewski and then members A.
Thank you, Chair Renahan, and thank you so much for attending today's meeting. Really appreciate it. My question is about domestic violence and survivors of violence. I believe that they strongly support this legislation because it allows the courts or the state to hold domestic violence people that are accused of domestic violence in jail without having a bond put on them, because I know families that have had the situation where abuser has been out on bond and has gone back to torment those families. And we have family shelter services that protects people, to keep their abusers away while they're out on bond. So I just wanted, if you could talk to that issue about how this really does protect victims of violence.
Yes, and I think that's helpful actually, because it also goes to the gentleman's last question about victims' rights. So you're absolutely correct. This new statute is supported by leading victims advocacy groups in Illinois, and that includes the Illinois Coalition Against Domestic Violence and the network. And it has more than 50 member organizations that serve survivors of violence and domestic violence. So to your point, that's correct. Right now, there is a system by where somebody, if they paid the cash bond, and in Cook County, for instance, most bonds are D bonds. So somebody has to pay 10% of the total bond. So if it's $50,000, they pay 10% of that and they walk out. And as you say, because most of those as I was saying, actually, because most of those cash bonds are not based on a risk assessment, it is possible, as you say, that somebody who is charged with domestic violence could, in fact, could pay that bond and then could leave. And obviously there are things like orders of protection, but those are not foolproof, and those require more work also for survivors, because they have to get that order separately. So yes, that is why survivors of domestic violence have gone on the record in support of this. They have gone on the record with, racial justice and economic justice organizations like Chicago Appleseed and the Illinois Network for Pretrial Justice, because of what you mentioned, that this is a system based on evidence. This is a system that looks to what an identifiable threat is to a specific person or persons, families, and considers that in determining whether somebody should be released. So I agree with you wholeheartedly.
All right, thank you. Krajewski is A, and then I think we're going to end questions.
If I had three, I guess I'll narrow it down to one. Only one question. And again, there's going to be a lot of changes. There's going to be some changes to this law, and I think that a number of the state's attorneys and law enforcement, including some of the members on this board, tried to have this discussion months and months ago before they actually did the law, but we have what we have today. And I know I agree with you. There's a lot of rhetoric out there from all kinds of people, social media, et cetera, and it's hard to get to what the actual truth and how this is going to operate. That's why I look forward to talking with the state's attorney and our law enforcement how it's actually going to happen. I'd love to see our chief judge come in here too, since he's been quoted. But my understanding is, the probational force felonies that are probationable, where we know cash bond, And those include aggravated battery, robbery, burglary, arson, kidnapping, threatening a public official, intimidation, hate crimes, second-degree murder, aggravated assault, disorderly conduct, threats against the school. Those, they can only be held if there's a willful flight risk. And I think you touched on that, right? Willful flight risk.
That's actually incorrect. Yes, they can be held if there's a willful flight risk, but many of the charges you mentioned also would fall under the detainable offenses because they involve guns. Ag assault is almost always a gun crime. Robbery is almost always a gun crime. Second degree murder is just really not a thing. Most people are charged with attempt murder or murder, which is detainable. So this idea that, and this has been honestly the biggest falsehood that's been making the rounds, that people are committing heinous crimes and that they just walk out the gates, it's just false, because these charges that are being listed are either not actually things that are charged very often, or they forget the fact that almost every gun offense, as well as domestic violence, stalking, various other offenses, are detainable, and often there's overlap in all of those. So, and also disorderly conduct was on that list.
Right.
We don't lock up people for disorderly conduct now, and we won't in January, and that's a good thing. Disorderly conduct is an incredibly minor offense, and often not based in real evidence, at least in the city of Chicago. So we don't want to be locking up people for DC, and we're not going to, and we don't now. So I think it's really important to hone in on what we're actually talking about with these charges, and how it will change, if at all, from what's in place now.
Yeah, I think you said we don't lock people up, and you said city of Chicago. Well, unfortunately,
The state of Illinois doesn't lock people up for disorderly conduct.
I'm speaking, and we're not in Chicago, and we're in DuPage County.
I understand.
We do lock people up, and we do lock people up for offenses. And we have over, 50% of these major felonies that are committed by people that don't live in our county. And they come here and they've been out for, various charges, but when we get them here, we charge them appropriately. And these people potentially flight risk. We have right now over 200 people on cash bond system that are not showing up for the court. So there's arrest warrants out for them. All these ones that get let out on a no cash bail, if they don't show up for court, and like I said, we have cash bail now and we have people not showing up for court. My understanding is there's no arrest warrant. There's a summons that's issued for them to reappear. We have to summons them to reappear. Is that correct?
So first of all, I just want to clarify what I was talking about
I
with
asked
people.
that.
Sir, please.
I asked if it was
You missed-
yes
All
or
right,
no.
Member Krajewski, come on.
I'm just asking her a question. Is it the issue with
Okay,
summons?
I had said one question per person.
My question. I'm still about this plate.
I will answer it. I promise. I was just saying that when you said that we are not arresting people for crimes, I meant disorderly conduct. I was focusing on that, and they don't detain people for disorderly conduct in DuPage either. That's just not what happens. As for people getting arrested who do not show up, you can the state submits a violation of the bond, and they can be arrested for that. And one of the ways people are held pretrial starting in 2023 is if they violate the conditions of their pretrial release, they can be held. That is another way to hold them. So anybody who doesn't show up, that's showing a willful flight. So they can be detained for that while their case is pending trial. I can't speak to who is being arrested in DuPage County, but it is on the state's attorney to lodge petitions to hold people, and he can do that. He has all the authority to do that now, and he can do it again in January.
All right, thank you. We're going to move on to Member Zay as our final question. I'm sorry, Garcia and Eckhoff, have your hands up. If you want to submit written questions, I will certainly forward them, Professor. But at this point, we do have executive session that's important we get to.
Thank you, Madam Chair. Professor, you had said a lot on stats about, people who spend time in jail, they lose, their jobs, they do everything else. The one thing you didn't mention was that they committed a crime, and that was their doing and choosing. So you kind of make them as victims here, but they're really not victims. They committed a crime. So, I think some of those stats are misleading. And you did quote, the Lake County State's Attorney, which is only one of 2 state's attorneys in the state of Illinois who are supporting the Safety Act. Do you think it's odd that 100 out of 102 state's attorneys do not support this Safety Act? I mean, it seems kind of strange at that point. But again, and you also brought up about fear mongering in the election. January 1st was picked by the state legislature, not by the body, not by the electives. So I'm pretty sure they knew that there was going to be an election 2 years ago at this point. So this isn't political. This was a date set by the Illinois House and the Illinois Senate. I mean, when they passed this legislation. But again, I mean, you have talked about, and it seems like you go back to a lot of gun issues. When we talk about probationary forcible felonies, aggravated battery, robbery, burglary, arson, kidnapping, threat to a public official. I mean, aggravated battery could be with a baseball bat, could be with anything else. There's not, you just seem to put this narrowly into a gun effect. And then again, you talked about defendants and the judge, so someone does.
Can you get to the question, please?
Yeah,
Yeah, well, I mean, you said a lot. I mean, again, if a judge can only issue a summons to appear if they don't show up and no prior history, if they have a history of not appearing, that's not looked at by a judge. They can't look at that. So they have to let them go if they have one of these forcible felonies. And so now you have to, if
Member Day, can you ask the question, please? We have other business to get on to.
well, again, if there's a summons to appear, the judge has to issue the summons to appear. So that means then our law enforcement, our suburban law enforcement, like Member Krajewski said, which 50% of the crimes are outside of DuPage County, have to go into other counties to try to find these people. That puts a burden on our law enforcement. So that's right. I mean, what we're saying is that if they don't show up, we have to give them a summons to appear. It's not an arrest warrant. It's only a summons to appear. Is that correct?
okay, you said a lot of things. So I think I answered this before. A summons to appear means show up in court. If they don't, you're going to show willful flight probably, especially if you have a record of people who have not shown up before, and then the state submits a violation of bond and they can be arrested. Again, though, if you open this up by talking about people who have been convicted of crimes, that they're criminals, none of the people we're talking about right now have been convicted. They've just been arrested. They've not been convicted. And so I really take issue with that framing of it. As for people who have also been released and are not coming back, these are people who have paid cash bail. If the state, again, Bob Berlin, wants to issue a detention order, he just has to file a petition to do so. Then they can be held no bond, and then they will not be released to not show up. So again, the burden is on the state. As for state's attorneys not having a role in the framing of this law was first introduced in February 2017. It was reintroduced in the 2020 legislative session a year before it passed. There were 3 subject matter hearings on the issue of pretrial justice reforms in 2019 and in 20, and it included experts, advocates, prosecutors, law enforcement. The changes made by this act mirror the majority of the recommendations made by the Illinois Supreme Court Commission on Pretrial Practices, which includes judges, which includes sheriffs, court clerks, prosecutors, police chiefs, and a public defender. So it's just a fallacy to say that there wasn't input from law enforcement or the state or court officials on this law, which has been pending for a long time. Now, I know that prosecutors are saying they are not in favor of it right now, but I mean, the burden does really rest with them going forward. They have all the power in the world to submit petitions to hold people and to prove to the judge by clear and convincing evidence that somebody should be held, because they have not been convicted of anything, and we have presumption of innocence in this country.
All right, great. You know what? I'm going to cut it off there. I think we could be here all day, right? And probably next week too. And I do apologize for the members that we didn't get to your questions. If you want to submit them, I will certainly forward those to Professor Van Brent. Maybe she even wants to come back one day. Maybe not. But anyway, thank you very much. You can feel free to turn off your Zoom. You don't need to stay for the rest of the meeting. Appreciate you being here today. Thank you all. Thank you all to this committee for a robust discussion. With that, I'll take a motion to entertain the approve the minutes of September 20th, 2022. All in favor?
Aye.
Any opposed? Those pass. I'll take a motion to approve procurement requisition JPSP 27422, recommendation for approval of a contract purchase order to Nolan Sales Corporation for carpet and flooring for the
Second.
circuit court clerk, not to exceed $220,336.17. Get a motion and a second. Questions? All in favor? Aye. Any opposed? That passes. I'll take a motion to approve JPSP 27522, recommendation for approval of
Second.
contract purchase order to Public Safety Direct Inc. for monthly maintenance and upfitting for the new sheriff's vehicles, October 30th, 2022 through October 29th, 2023, not to exceed 260,000. Questions here? All in favor? Any opposed? That passes. I'll take a motion on JPSP 27622, recommendation for approval of a contract purchase order to Sentinel Offender Services to provide GPS device and electronic monitoring services for juveniles and indigent adult offenders and their victims. This is for the probation and court services, October 30th, 2022 through October 29th, 2023, not to exceed 306,000. With a motion and a second. Questions here? All in favor? Any opposed? That passes. I'll take a motion on JPSP 27822, recommendation for approval of a contract purchase order to William G. Rohrbeck,
Second.
attorney at law, a conflict attorney for the court, November 1st, 2022 through November 30th, 2023, not to exceed 47,500. Had a motion and a second. Questions? All in favor? Aye. Any opposed? That passes. I'll take a motion on JPSP 27922, recommendation for approval of contract purchase order to Progressive Communication for the purchase and installation of audiovisual equipment and upgrade for the jury commission, $32,759 for the court. We had a motion. Was there a second? Thank you. Questions here? All in favor? Aye. Any opposed? Right, that passes. I'll take a motion on resolution FIR 39522, acceptance and appropriation of the State Court Improvement Program
moved.
FY22 grant, $5,000 for the court. We have a motion and a second. Questions here? All in favor? Aye. Any opposed? That passes. Moving on to budget transfers, I'll take a motion on 9A, transfer of funds from salaries and maintenance supplies in the amount of $220,337 to replace
moved.
carpet for the clerk. And a motion and second. Questions here? All in favor?
Aye.
Any opposed? That passes. Take a motion on budget transfer 9B, transfer of funds $70,000 for the state's attorney
So moved.
to pay 10 law clerks hired as temporary employees until they are sworn in as attorneys, when they will be full-time assistant state's attorneys. In a motion and a second. All in favor? Aye. Any opposed? That passes. I'll take a motion on 9C, budget transfer. This is transfer of $2 to pay a CDW invoice to the
Second.
state's attorney. A motion and a second. I will make a comment here that is crazy ridiculous that we have finance rules that are requiring this body to pass $2 change. So I think we need to work on that. All in favor? Aye. Any opposed? That passes. I'll take a motion on travel request 10A for Office of Homeland Security
So
and Emergency Management going October 25th to 26th to Bloomington, Illinois, and there is no cost to the county of this. We have a motion and a second. Questions? All in favor? Aye. That passes. Take a motion on 10B. This is overnight travel also for OHSCM.
So
This
moved.
is for the coordinator to go to Urbana, October 6th and 7th, 2022, doing some very important training exercises and doing some training for ILEAS. And I'll take a motion in a second. There's no cost. All in favor? Aye. Any opposed? That passes. I'll take a motion on 10C. This is going to the same
So moved.
same thing, authorization for overnight travel. This is for staff to travel to Urbana, OHSCM to travel to Urbana, October 6th and 7th, 2022 to participate in training. All in favor? Aye. Any opposed? That passes. All right, moving to old business. Yes, member Zay.
Thank you, Madam Chair. You know, that was ridiculous. And you know, you're one of the chairs that complain about not enough time. You know, you have executive session. You know, this is a big issue. Well, at first, 2 years ago, you said this wasn't, many of you here said this was not a county problem. So I don't know how it became a county problem all of a sudden during election time, but for pure political process. To have a speaker here and not allow every member of the committee ask a question is just ridiculous. And it's poor leadership at that point. You should have had a special meeting or had it, that's this person come to the county board next week when the state's attorney and chief judge are coming, so we can have a discussion on it or call a special meeting. But to have somebody in to give their point of view and take a few questions and then say we have to move on, it's just not the way we do things in DuPage County. And maybe that's the way you do things, but that's not the way we do here. Most committees let people ask questions ask multiple questions, to limit questions and limit the amount of questions was just a shame and it was ridiculous.
All right, thank you for your comment. Member Ozak.
I want to thank you for having the professor here today. I think she gave a different viewpoint from what we're hearing in various political issues right now. And I think the comments were not necessarily questions as much as they were discussing where the crime comes from in DuPage County. We like to keep talking, you all like to keep talking about how all the crime, 70% and it's 50%, what the amount is coming from the outside. What do you plan to do? Build a moat? Because we exist because of Chicago. We exist as a region. So to continue this narrative it's not appropriate. It's really, well, 5 weeks. As I've said before, we're 5 weeks from this election. So to fearmonger that this is going to change and release criminals all over the place, and she gave a different perspective, is not poor leadership. It's giving a different perspective from what the opposition, my opposition, is putting out there. Thank you.
Member Garcia.
Yeah, and I wanted to thank you, Chair Renahan. I think this was more of a matter of just stating the facts. I know, we keep saying perception, but I don't think that was what was being done today. I think it was, this is what the facts, this is what's going to happen. And that needs to be cleared up in today's dialogue that we're having here. So I appreciate you doing that. And I know it was brought up that, if there are crimes being done in Chicago, what's going to happen to people in DuPage? Well, I do think that our police do talk to the Chicago police. I think that there is communication that's done between all of the departments. And I think this is just going to make the communication better between all departments. So I think that we'll have a better communication at the end of all of this. And so I just want to thank you. And I would hope that we would get, maybe a sheet from the speaker today, with some of the facts that she stated, so that we can have those to just refer to as we do have the next presentation. So I thank you.
Okay, good suggestion. Member Covert and then Member Chaplin.
Thank you, Member Ranahan. I do appreciate your efforts, and we've been talking about this issue a lot. My only thing is, my firm does criminal defense as well, and we have a partner who does criminal defense. So there's a lot of realities, that we have to face with clients, and it would be helpful if we could have other perspectives of people who are practicing in this area to discuss, what is happening. My issue with the presentation was just, there were a lot of presumptions made about what judges do or what judges don't do. And I didn't hear any evidence or statistics, or I'd like to hear more of that. Just stats and facts and evidence. There was just a lot of buzzwords that I don't like, and there were, mislabeling of different crimes and saying disorderly conduct is minor. I mean, there have been cases of disorderly conduct where, I could go into cases where there was a person in Aurora who had a truck, and they didn't know if there were bombs in there, and he was yelling death to everybody at a casino, and he was bashing, slot machines with a bat and saying that he's going to blow the place up, and he was convicted of a disorderly conduct. So, you really have to look into the crime itself, but I just wish the presentation was a little tighter. That's all, with statistics and facts, no presumptions about police or what judges do. That's all. But I do appreciate getting a different perspective. Thank you.
All right, thank you, Member Covert. I'm going to go to Member Eckhoff because he was left off in the beginning. I'm sorry, and then Chaplin.
Thank you, Madam Chairman. I would have liked to have asked the speaker a couple of questions, and I'll tell you what some of them are right now. I read the same biography that you read because I Googled her when I saw that we were going to have her as a speaker here today, and I didn't see anything in her bio. Maybe there is something, but it was left out, that indicated that she ever worked in the private sector, or for law enforcement, or for the state's attorney, or a public defender. I saw that she went to law school, and that she seemed to have jumped straight to Northwestern. So I would have asked her to fill in the blank, and maybe that could be a question that is submitted to her. Second is, I pulled up the section of the bail bond law as it exists now, And there's probably, if you print it out, about a page of factors that are supposed to be considered aggravating by a judge. And then there's a series of factors that are supposed to be considered mitigating by a judge when they determine what bond is. But it specifically says that there's a presumption against monetary bond. And if there is monetary bond, that they're supposed to consider the financial ability of the person to pay. And so it seems to me, I wanted to ask her what is wrong with that system. She seemed to be saying that the judges today are not following the law. If they're not following the current law, I don't understand how she expects them to follow the future law. And it seems like the proper remedy is to take the decision of the judge up on appeal. So one of the big questions we had back in '94, when I know some of you weren't around, when the assault weapon ban was put in, was we had this law called 3 strikes and you're out. And it took discretion away from the judges, and it put a lot of people in jail supposedly because the 3rd strike was a namby-pamby offense, but they had to go to jail because that's what the law said, and we had taken discretion away from the judges. And then I saw Bill Clinton, when he was supporting his wife for president, being called a racist because he had signed that law. And that's what it seems to me, and I wanted to ask her, aren't we taking discretion away from the judges today under this new law? And we learned that taking discretion away from judges is bad 20, 30 years ago with the assault weapon ban. If we're doing that again today, even though it's on the opposite side of the spectrum, why isn't that bad too? So if you want to send her all those questions, that's great. Thank you for calling on me. I have to go to court.
Thank you. Member Chaplin.
Thank you, Member Renahan. And I want to thank you for your leadership on this committee and for all that you've done. I think the only thing ridiculous about this whole thing is all of the misinformation that has been put out there by respected elected officials. That is really disappointing, and that is what is ridiculous. And as far as that goes, I'm going to go on this. As far as presumptions being made, again, those presumptions have been made by, there's been a lot of presumptions made by our elected officials right here in the county that have been incorrect. I don't think, honestly, that anybody wants an unsafe community. I don't believe that Democrats want an unsafe community, and I don't believe that Republicans want an unsafe community. I have children. I hope to have grandchildren. I want people, everyone, to be safe. What this legislation does is it allows for equity in our system, and I believe it is going to make us much more safer. And let's face it, change is scary. It is uncomfortable. People don't like going into the unknown. But I have a feeling after November 8th, we're not going to hear much about this anymore. I think it's going to go away, and I hope it goes away. And again, as I said, if there are issues with this bill, everyone should be talking about the issues without scare tactics and sensationalism. I believe every state legislator out here would be willing to work on changes to this legislation. Like I said, if there are changes that need to be done, put it out there and let's get it done. But this crime purging and all this stuff, that is what is ridiculous. That is what is shameful. And I really appreciate you having another perspective in here, because when we did the progressive tax debate on this floor, we had both sides in and to discuss that. And it is important to have other views on this. And this professor here is not just a Stanford and Brown University graduate. I think she might know a little bit about what she's talking about. Disrespect shown to our speaker, I'm embarrassed about that as well.
You know, I'd like to comment on that too. I mean, I'm sorry, members, we weren't able to reach everyone, but maybe if members were not grandstanding and doing so much commentary, we would have had more time to get around everyone. Member to start. Thank you. I just want to compliment you on your leadership as well. I want to talk about a different topic. Over the weekend, there was a bomb threat at Harris Casino in Joliet, and I understand that some of our DuPage County assets went to help our neighbors, and I just wanted to show my appreciation for that. Thank you. All right, thank you. Do we have any new business? All right, with that, we need to take a motion to. Yeah, members A.
Yeah, I'm just confused during new business. I don't remember any of my colleagues fear mongering or saying anything political. It seems to be from the other side. I mean, we're just asking questions, not taking stands. I mean, some comments were made today. I mean, maybe there's our undersheriff and one of our chiefs here. I mean, the comment that this is going to make police work easier and that they're going to communicate with the city of Chicago. I find that hard to believe. I mean, maybe they can answer that this legislation is going to make their job easier. I mean, they're here. Do they want to talk about it? Or, I mean, but my comment is we could just make these blind statements and nameless statements that elected officials are saying this or saying that. None of our colleagues are saying anything on the board. We're asking questions. I mean, nobody brought politics up. Nobody brought anything up. Again, we didn't select this date. We wanted an open debate when we asked this board to veto the legislation 2 years ago, and we were denied. And then I guess maybe that there's new legislation out there to change the Safety Act and clarify some of this, then maybe we should bring that forward and have the board vote on that to, again, make these changes. But again, as it was brought up, the state's attorneys, we were told by the state legislator that there would be changes, and that's happened over the last 2 years and nothing's happened to clarify some of this, and nothing's happened from the state.
Thank you, members A. Member Ozog, and then we're going to move into executive session.
Thank you. I think using words like ridiculous about our chairman here is certainly inflammatory and unnecessary. If you listened to what the professor said, there is a different viewpoint here on getting rid of cash bail. I'm not an attorney, but I understand that there's no cash bail at the federal level. So getting rid of cash bail is not going to bring us violent criminals on the streets, which is the fear mongering that's going on right now. And when you start talking about all the criminals coming in from outside in Chicago, in front of me, I have a text that was sent out. Are you okay with violent criminals from Chicago coming into our neighborhoods and making our families less safe? Are you okay with rising inflation and high taxes? If not, it's time to fight back. This is DuPage County GOP Chairman Jim Zay. Reply GOP or go here to get involved. That's a text that was sent out in the last week. So we really need to look at how this is actually going to affect us versus the fear mongering that's been going on. And I thank Chairman Renahan. I don't think this was ridiculous, and I think it gave us a different perspective. Thank you.
Point of order, just to respond.
Members A, and then we really do need to move to executive session.
I mean, I guess our members don't really listen. I said it was ridiculous that we didn't have the time to ask questions and that we
Poor leadership.
Well, and that is, if you don't have a speaker come, which is good to have other point of views and be able to ask questions in our committee structure, especially from a chairman who's complained that we don't have enough time, but then have a large agenda and bring somebody in that is going to be inflammatory and people are going to have questions. And she made a lot of statements that people wanted clarifications and answering because, again, we all know this act isn't really written that well and there is confusion on it. But again, to have somebody come and only limit questions and not let the full committee ask questions, that's what I said was ridiculous, that you should be given that time for everybody on the committee to ask questions, ask multiple questions if they want, because that's our job to ask questions. Nothing about not them having her. I'm glad that she came here. She's an academic. She has a point of view. I'll go with the other 100 states attorneys that are against the Safety Act and our states attorneys and our public defenders who actually are in the courtroom every day and practice law. That's who I'll go with. So hopefully next week when the state's attorney comes and the chief judge will get more clarification on this bill.
All right, thank you. And you know what, I really, there's probably not a legislative body or Supreme Court or anything when there's really enough time to answer all the questions and to get around to everyone as much as possible. So I appreciate your input, members A, but respectfully, I think if we had kept to questions and not commentary, I think we would have had more time to get to those questions. I will take a motion to move into executive session.
So moved.
This is on Open Meetings Act regarding security procedures and use of personnel and equipment to respond to actual threat and unreasonable potential danger. We have a motion and a second. All in favor?
Aye.
Any opposed? Oh, I'm sorry. I need a roll call for that.
Oh, I'll take it.
Here. Aye.
Aye.
I'm so sorry. Okay, Member Desart, Member Eckhoff, Member Garcia,
Aye.
Member Krajewski, Member Ozog, Member Pachowski, Member Schwarzy, Member Selman, Member Zay.